Numbers 42 and 43, People versus Jeremy Shue, 19378 FH, 18855 FH.
Jessica Blanche, appearing on behalf of People.
Good afternoon, Your Honor. Stuart Collis on behalf of Mr. Shue. May we approach, Your Honor?
Good afternoon, Mr. Shue. Can you hear us?
Yes, sir, I can. How are you?
I'm okay. Mr. Collis, have you had a chance to review the email from probation requesting additional counts be added?
I have received that this morning. I tried to meet with Mr. Shue about it at the jail, but apparently he is in observation, so I was not permitted to see him today. So I have not reviewed it with my client.
So it sounds like we probably need to adjourn this because there's a number of them and you're going to need to go over them, correct?
I would ask that it not be adjourned, sir.
What? I'm sorry, Mr.
Well, as Mr. Shue, I got to tell you, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 added counts being proposed, and you haven't had a chance to go over those with your lawyer. So I don't know how else we would approach this.
How else we can approach it, sir? May I speak, Your Honor?
Sure.
How else we can approach it is pursuant to People versus Glass and People versus Vanderpool. The probationary period expired as of June 5th, 2022. The court is without jurisdiction to hear any of the new added counts because my probation order ended June 5th, 2022, sir. The probation did not have a hearing pursuant to MCL 771.5 and 771.6 prior to the probationary period ending, and the probationary order was not amended pursuant to People versus Glass 288 Mish App 399 and People versus Vanderpool 505 Mish 391. Probation order was not amended to include any of the conduct that occurred after June 5th, 2022.
So I appreciate that you are able to cite those cases, but typically that would come to the court on a motion. So I wouldn't just sort of off the cuff make a decision based on you or your lawyer, citing case law to me. So do you want to ask Mr. Collis to file a motion to dismiss all of this based on the grounds that you just cited?
Yes, I would also request that the court give me a personal recognizance bond pursuant to MCR 6445C, because the people cannot have the probationary hearing within the 14-day period that's allocated.
Mr. Shue, I was about to address bond. Your Honor, as my client indicated, originally the probation violations in this case, while there were some technical violations that were cited prior to the proposed amendments that had been proposed by probation, were centered around two cases that Mr. Shue had in 1484 and a felony charge.
Mr. Collis, I'm not going to decide this today. Okay. So unless you are saying to me, hey, Judge, I'm ready to file a motion, I'm happy to have you say that to me. Otherwise, I'm not going to have your client cite cases and you tell me a procedure that's going to urge me to make a decision on this. So if you'd like to, I'm happy to have you file a motion, and I'm happy to give you as short or long as you need. If you want to hear this next week, we can, but I'm just saying we're not going to decide it today.
I would ask, I'll just, if we could have this adjourned, and I'll file a motion for the 28th as well. That would be fine.
So how far out should we adjourn it?
2 weeks, Your Honor. That's what I was asking.
What's that?
2 weeks, Your Honor.
Okay. So that's September 28th at 1:30. Mr. Shue kind of spoke over you and made a bond modification request.
That's what I was starting to argue, Your Honor. I wasn't talking about the other motion.
Okay, so don't give me the lengthy history of the case. I'm pretty familiar with it. So why would I release him today
Very
on
well, Your
PR?
Honor. Because the primary violations, which were a new felony charge and a misdemeanor charge, were dismissed. Those cases did not go forward. The new allegations that are made here have to do apparently with Mr. Shu's disappointment at not being immediately released because he thought that he was going to be released after the felony and misdemeanor case. I think that he's less of a threat to society outside than he is somewhat inside the facility. All these crimes that he's had in the past are basically petty thefts and the like. He's non-assaultive, other than the alleged incident with his girlfriend. So I would ask that we reduce to either a PR bond or some bond with a small 10% so that Mr. Shu can make that. He is innocent.
Or possible.
So that would help.
Okay. Happy to hear from Ms. Blanche and or Agent Benetti, either or both of you.
Judge, he continues to violate his probation. He has numerous new violations. He has numerous prior violations. And just because 2 cases got dismissed because the victim was uncooperative doesn't mean that people can't proceed on them for probation violation. I'm asking you to have him stay in custody based on his behavior and his continued behavior. If you want to release him to some mental health facility where he's inpatient and he's away from people, I'm fine with that. But he needs to stay in custody, Your Honor, based on everything that he's done.
Anything to add to that, Agent Benetti?
No, Your Honor, only just clarification that there are only 2 additional counts that have not been already placed on the record. I did email Mr. Collis this morning and copied your staff as well as Ms. Blanche and added just the prior violations for clarity purposes.
You sort of summarized it in the 2 new ones, right?
Correct.
Yeah, I counted them all. I got that. Sorry. Yeah.
Yeah. So the 2 at the top are the only conditions that we're requesting, or I'm sorry, violations that we are requesting be added at this time. Those are still being looked at by the sheriff's office. It's my understanding that they are going to request new felony charges. So we would just ask for an adjournment in order to track that.
All right. Mr. Shu, you have your hand up. You wish to speak?
Yes, I do, sir. Sir, I would be willing, my uncles both have health issues. I would be willing to submit to a tether. I am no threat outside of the jail. I do not have no pending cases. The only thing that is holding me currently is this probation violation. My probation has been over since June 5th, 2022, sir. I almost completed probation. The only thing that violated my probation was the allegation of domestic. The allegation of domestic was dismissed. My fiance, I am currently under an order not to be in contact with my fiance. I cannot, I'm no threat in the jail. I will submit to a tether. I'll submit to community corrections. My mother needs me because of my uncles having health issues. My mother is 63 years old. She cannot take care of my uncles. My one uncle has severe cerebral palsy, lives in Wayne County. I would be happy to submit to a tether. I'll submit to community corrections, drug testing, whatever the court asks. I am no threat to anybody outside of the jail. None of my crimes are violent. No crime I have been on probation for, no crime I've had in my history is violent. I would be willing to submit to whatever the court requests pursuant to the MCR subsection 3. I'm actually entitled to a PR bond. So that's really all.
The problem is that while I appreciate everyone has family situations, sir, and you're not guilty of any of these violations yet because we haven't had a hearing yet. But I do get to look at the allegations and make a decision on bond based on that. And all of these allegations, or at least a fair number of them, do involve threats of physical violence, I know that you're not, this is not a conviction, but it's alleged that you said to a police officer, I should punch you in the face right now. I'm going to get you when I get out. It's alleged that you, I guess.
May I refute that, sir?
It doesn't matter. I'm not saying you're guilty of it, but the fact of the matter is they're allegations, and you're telling me you need to help your mom. Well, if you really need to help your mom, if you didn't say those things, then there's a huge conspiracy. But if you said something that could be construed as a threat, that's not helping your mom.
I had a seizure. Okay. I came to with the officer in my cell cleaning up water on the floor after I had a seizure when they did not call medical staff. I have a referral to neurology for my spinal issues. I still haven't seen neurology in 3 months, sir.
Well, we're going to go out 2 weeks and maybe you'll be out on your motion. So I'm going to remand you for the hearing 2 weeks from today. Mr. Collis is going to file a motion.
14 days already, sir.
Okay, well, we're going to continue until the next hearing.
Thank you, Your Honor.
Number 50, People versus Charles Thrower Jr., 22
This is
452
straight
FH.
bullshit, man. Like you're fucking playing games with me.
Keep talking, Mr. Shu. You're on the record.
I know I'm on the record and you're on the record, man. I haven't done nothing. I'm being retaliated against clearly, and I don't understand. I haven't even seen my attorney. I don't get what, like, under the MCR, you have to let me go. I haven't done nothing. MCR 6.445C. Under MCL 771.4 through 6, my probation has been up. People versus Vanderpool.
Judge, I think his attorney left the Zoom. Can we mute him until his attorney comes back, or can we pass him to another matter?
Under People versus Vanderpool 505, this is the same lady.
I mean, we're not going to pass it, so we can.
Can you just mute him and call the next case then? Because Mr. Collis isn't even in the courtroom.
Number 50, People versus Charles Thrower Jr., 22 452 FH.
She's clearly retaliated against me.
The problem is, Ms. Blanche, we can't permanently mute. Big tell there. It's only a temporary mute.
I'm sorry, what case
Mr.
is
Goldstein,
called?
your appearance.
David I.
Just
Goldstein appearing on behalf of the defendant.
Mute me anyway.
See what
Judge,
I mean?
I didn't hear the case. I didn't hear the case you called.
Charles Thrower.
It's, People versus Thrower.
Okay. Jessica Blanche.
22-452 FH.
Thank you, Your Honor. Jessica Blanche appearing on behalf of the people.